what are some of the general things that you talk to people about when they're deciding whether to hire an employee or a contractor?
So, they're coming to an employment law attorney and, the owner and operator of the workplace law firm. So I always say that employment laws are for employees. They're not for independent contractors. So I really want to see, number one, are they already using any independent contractors? If so, what are the dynamics to that relationship? Is it a true independent contractor relationship, or does it really look like an employment relationship, but they're just maybe misclassifying the workers? So if it looks and smells and seems like an employee relationship, then they should be an employee. What does that mean? Employees are generally paid for the services they perform, let's say by the hour. Contractors may be performed or may receive payment based on a project. Let's say a flat fee based on a project. Workers, employees generally work a set schedule, and they're subject to the control of their employers. Independent contractors are really supposed to come and go as they please, set their own schedule, and do everything that is necessary to complete the project. Employers tell their employees what to do, when to arrive at the job site, to complete paperwork, to undergo training, for example. Independent contractors are already supposed to be in business for themselves. They're supposed to know what to do. They're supposed to have been trained already on the project or task at hand. And they're not taking direction, so to speak, from the employer. So when I see a lot of companies that begin to treat 1099 independent contractors like they do their employees, we have to have that tough discussion around possibly converting these workers to W-2 because there's risk of misclassification. And what are some of the risks? Number one, if you're paying somebody as a 1099, you're not doing payroll withholdings, right? You're not paying the taxes associated with having an employee. They receive a 1099 form at the end of the year, and presumably they pay their share of taxes at that time. Number two, you don't have workers' compensation insurance for these workers, okay? So if someone gets injured on the job and you don't have workers' compensation insurance, well, there's a potential claim for you. And like I always say, 1099 workers or any workers in general will use the 1099 preference when it suits them. But if it suits them at a later time to be a W-2, let's say for workers' compensation benefits, then they're going to change their preference. And the law doesn't really care about anybody's preference, by the way. They're going to look at the dynamics of the relationship, which I talked about before. And then also some risk of misclassification is you may not be paying the employees at least minimum wage or overtime, which then you have a wage and hour issue. So these are just some examples of a variety of reasons to really make sure that you have the characterization done properly, and that if you don't, you convert the workers in a delicate way. You should do it with the advice of counsel, of course, and begin to treat and pay these people like true W-2 employees. That said, I imagine in your world, Justin, that there may be a difference in intellectual property treatment towards employees versus independent contractors. Can you shed some light on that?
Yeah, absolutely. We have, so you have, you know, the whole world's gone to contractors, employees all over the place and doing all different things. And a lot of these are virtual workers who are creating content and creating software. They're doing all sorts of different things. And from an IP perspective, there's a really big difference between somebody who's an employee and a contractor. And just to make it in simplistic terms, essentially the law favors the employer if the person is an employee, and the law favors the contractor if the person is a contractor. And what that means is, for example, if they're developing software, most of the time, if they're developing software as an employee and it's within the scope of what you hired them to do, then that's going to be owned automatically by the company. And it actually is owned in a way as a work for hire, which basically skips the employee. It's as though the company created it itself. And but the opposite is true if somebody's a contractor. If somebody's a contractor, then there is no presumption that even if you pay money for somebody to develop something for you, if they're a contractor, without a writing, you won't own it. And so it's a very, very different, a dramatic change, just depending on what type of person is touching the same project. So I think it's important to think about what types of workers you have, especially if you're a developing software, developing something with intellectual property, to make sure that, okay, this person, we're paying them as a contractor, so then we need to do X, Y, and Z for that person to make sure that we're getting all the rights. And this other person is an employee, so maybe we do something slightly different for that person.
Yeah, I think those are great points. And I think just to kind of close, that point, it seems to me that, with the body of employment laws and the body of intellectual property laws, it's probably in the company's best interest, not legal advice, to strongly consider the W-2 relationship versus that of the 1099. At least that's from my perspective. I don't know if you agree or disagree.
So, I'm agnostic on that, but it does make things a little easier. I mean, it certainly makes things easier, but we can manage it from an IP perspective and get those rights either way. But it does make life easier to have the defaults on your side. So for sure.
Sounds good.
Well, cool. Well, great talking to you. Let's we'll do some more of these and pick some other topics to overlap.
Yeah, sounds good. Have a great day, Justin.
All right. Take care, Adam.
Take care.
Be well.